Hi, Misha Gill with Speedwell Law. Today I'm going to answer a question that I get a lot. What's the difference between a will and a trust? All right, so let's just start with the will. A will is a testamentary document that goes into effect when you pass away. The administration of a will is overseen by the courts. Specifically, the bulk of the administration is going to be overseen by an office called the Commissioner of Accounts. That means that you're going to have to account to the Commissioner of Accounts for every dollar that goes into and out of the estate before you can get the approval to wrap up the estate. So what you're doing when you are sending someone to probate is you're sending a fiduciary to the court to qualify, and you're getting the court's permission to act on the estate, an authority to act on the estate, and then that fiduciary is going out and marshaling the assets, accounting for the assets to the Commissioner of Accounts, and then distributing the assets. Sometimes it's a really good thing to have a judge help you resolve any disputes that arise. That's one of the benefits of our justice system, is having a judge available to help you with those kinds of things. But the thing to know about probate is that it's optional. You don't have to go through probate if you do proper planning. And so why would we want to avoid probate? Well, for one thing, it's always stressful to go to court and ask them for anything. So you can save your loved ones the heartache of having to go to court. For another thing, it's public record. So everything that you own when you pass away gets disclosed to the public via the Commissioner of Accounts. And so then that means that creditors, potential creditors out there, might have an idea of whether your kids inherit a large amount of money. That might make them more likely to sue them. Finally, it's expensive. Probate costs are the court costs and the lawyer costs. So for an estate that is $500 to $1 million, you're looking at about $1,500 to $2,000 of court costs. And that's before you hire the lawyer. Now, if people start fighting about things, if there are any disputes that arise, well, the cost of probate can obviously skyrocket. And so if you turn your estate into a non-probate estate, then you don't have to go to probate. So how do you accomplish that? Well, you accomplish probate avoidance by titling your assets such that they pass by operation of law. And so we're talking joint tenancy on bank accounts and real estate, or we're talking about contracts with your institutions in the case of beneficiary designations, pay on death designations, transfer on death designations, or in the case of real estate, turning it into a non-probate asset by titling it in a living trust. And so a living trust is a contract between yourself as an individual and yourself as trustee of the trust to hold everything you own in trust during your lifetime, amendable, revocable by you, and then it becomes irrevocable when you pass away. So a living trust passes things by operation of law because it's a contract. Now, in the case of real estate, it's critically important to get your asset into the trust during your lifetime so that it avoids probate. Now, if you have real estate in another jurisdiction, it's critically important that you avoid probate because if you have real estate in another state, then it's going to open up another probate, what's called an ancillary probate in that jurisdiction. You just doubled the cost of your probate. So if you own real estate here in Virginia and another piece of property in Florida or Maine or California or anywhere, then it is critically important that you do a little bit of estate planning with a living trust. Now, the other nice thing about a living trust is that it provides a lot of protections. It becomes irrevocable. It gets artificial personhood when you pass away. And so there's a lot of features and benefits that you get when you do planning with a living trust, and it delivers a lot of value in saving you costs and fees and the heartache and the time and the difficulty of going to court. So probate is optional. If you want to create a will, then you know what you're getting into. If you create a living trust, you know what you're saving your loved ones. So thank you for watching my video, and I look forward to meeting you.